Hello, and thank you for joining me. If you or your company is currently involved in civil litigation or may be in the near future, this is an important update for you to be aware of. As of 22 April 2025, the Gauteng Division of the High Court has implemented a mandatory mediation process for all civil matters. This means before your matter can be allocated a trial date, you are now required to first attempt mediation. The change was introduced in response to a serious challenge in the court system. The backlog in trial dates has become so severe that new trial dates are being set as far out as the year 2031. For many litigants, that delay amounts to a denial of justice, so the court has acted to change course. Let's look at what this means in practical terms. If your legal team is preparing to request a trial date in the High Court in Gauteng, the registrar will not consider your request unless you have submitted a mediator's report. This report confirms that both parties attempted to resolve the matter through a structured mediation process and that it either succeeded or failed. The mediator must be a qualified professional and must file the report in the format prescribed by the court. Without that, your matter simply will not move forward. This applies to all civil matters, including road accident fund matters, but there are some transitional rules to be aware of. Here is the breakdown. If your trial date is already set before 22 June 2025, it can proceed as planned. If it is between 22 June and 31 December 2025, it may still go ahead, but a mediator's report must be filed at least 7 court days before the hearing. From 1 January 2026 onwards, all previously scheduled trial dates for road accident fund cases have been withdrawn. You'll need to reapply and mediation will be the first step. For non-RAF matters scheduled for 2026 or later, the report must be submitted 30 court days before trial. If the report is not filed in time, the court will strike the matter from the roll with no order as to costs. What does this mean for business? First, it means litigation strategy must now include mediation planning from day one. You cannot afford to treat it as an afterthought. Second, mediator fees are shared equally by both sides. This is a cost your legal team must now budget for in advance. Third, failing to follow this process risks not only delay, but reputational and financial consequences if your matter is struck from the roll. And finally, while there is currently a constitutional challenge to the directive pending, the rule remains in force. In other words, compliance is not optional. So what should you do now? If your company or you is pursuing or defending a civil claim in Gauteng, make sure your legal team is briefing you properly on these changes. Review any trial dates already scheduled. Confirm that mediation is booked early and that your legal team is engaging with an accredited mediator well in advance of deadlines. At its core, this directive is about restoring access to justice. And for businesses, it's also an opportunity to explore resolution sooner, often at lower cost and with less reputational risk. If you have any questions about how this change affects your current or upcoming matters, I encourage you to speak to your attorney as soon as possible. Thanks for watching.